Good afternoon, everyone, and welcome back to the KW Property Management and Consulting's Best Practices Monthly Webinar for Community Associations. I will be your host, Tim O'Keefe, an Executive Director and Partner with KW Property Management and Consulting. Last month, we had a very healthy discussion during this webinar about rising insurance costs in Florida and what the state legislature did to try to tackle some of those issues in their special session last month in December. Not a lot was done, but to tackle lowering the costs, but they did make an effort to try to put some controls around what's happening in the market. I often use these webinars to make a public service announcement. So I saw something yesterday that I thought was worthwhile making my public service announcement, which is the U.S. government will send each household a free COVID test kit again. If you're interested, you can get a 4 COVID test kit at no charge. You can go to covidtests.gov. That is covidtests with an S.gov, and put your home address in there. It's real simple. I did it just to make sure it worked, and it accepted my address. So if you want to get COVID tests, better to have them before you need them, because once you need them, it's always hard to find them, it seems. Okay, so let's move into our discussion for today. The first quarter of the year is election season for many community associations. So today we will address best practices for the election process. We have a great panel of experts joining us. So if you have questions, please find the Q&A icon at the bottom of your screen and type in your question. We'll do our very best to answer all the questions that we received today. We also got questions in advance from many of you that signed up for today's webinar. So we will get those questions asked and answered the best we possibly can. So let's get started by introducing the panelists. First, we have David Muller. David is the managing shareholder for Becker's Naples office. David concentrates his legal practice on community association law. He primarily represents condominium, cooperative, mobile homes, and homeowners associations. He represents community associations located throughout Southwest Florida. David, you've done this with me before, so welcome back.
Thank you for the invitation. It's great to be here.
My pleasure. And also joining me again today is Bruce Masia. Bruce is a vice president and partner with KW Property Management. Bruce is responsible for the service level and operations of our Broward and some of our Miami-Dade book of business. Welcome back, Bruce.
Thanks, Tim.
We do have poll questions that probably popped up when you joined, so you can respond during the webinar, and I will share those responses as we move through the day. If you have any questions for our panelists, again, click your icon at the bottom of the screen and fire away. We'll do our best to answer them. David, let me start with you if we could.
Yes.
So before we, we'll deal with some of the technical stuff first, okay? So we have both condo board members and HOA board members, as well as managers on the call today. So can you point us to what parts of statute 718 and 720 actually address holding elections for anyone that cares to read more about these rules and statutes that we have?
For sure, yeah. There's specific language in both of those statutes, and all the statutes governing elections. I believe for condos, it's 718.112, if I recall correctly, and then for 720, 301 or 3, I've got the statutes here, but there's a section in there. We're going to get to HOA elections. One of the things we're going to cover here. The phrase I like to use for HOA elections is it's the wild, wild west. So we'll later on kind of explain what that's all about. But there are definite procedures that are mandated by statute. And one thing a lot of folks may not realize, there's also something called the Florida Administrative Code. The Florida statutes, that's the language that the politicians vote on and approve up in Tallahassee. There's also the Florida Administrative Code, abbreviation FAC, when you see legal writings and things like that. And the Administrative Code is prepared by the administrative folks up in Tallahassee as a supplement to the statutes. And the reason I mention that is it's important to know about the Administrative Code because they do tackle issues with elections and things like that. As an example, there's language in the Administrative Code that talks about what to do in the event of a tie. Of course, your own governing documents might cover that as well. But the statutes in the Administrative Code, and then of course your governing documents, those are the places you look to for authority and figuring out how to properly conduct these elections.
So this is a question for a condo. Does every condo need to hold an election, or can you be too small to have an election?
Right, so the statutes talk about if you are a very small condo, I believe it's what, under 8 or 12 or something like that, under a certain number that you can vote to opt out of the mandatory procedures contained in the Condominium Act. So depending on your size, if you want to go your own way, there may be some flexibility there. But for most of the folks probably on this webinar, most of the folks, they're going to have to follow their statutes in conjunction with the governing documents.
Okay, great. And then Renee from Fort Lauderdale, I'll get the first attendee question here. She wants to know what requirements outlined in governing documents can affect the election process.
Right, so it's a great question. You have the statutes which say what they say, but you also, as I mentioned, have to focus in on the governing documents. There can be particulars in terms of who is able to vote. As an example, if a unit or a lot is owned by what lawyers call an artificial entity, what I mean by that is a corporation or an LLC or something like that, sometimes there can be specific requirements in the governing documents that talk about being required to designate a primary owner or primary member, and that person that's so designated, they have the ability to vote on behalf of that unit or lot. So those are the types of things you have to be familiar with, because if there is an election dispute, right, and Murphy's Law being what it is, if there's somebody wins by one vote, the final spot, there could be a challenge that comes, and somebody might need to take a deep dive into all sorts of the minutia of these things, including what does the deed say, who's actually able to vote for that particular unit or lot. So it's a great question. You need to be cognizant of those things. The two really work in conjunction, governing documents and the statutes.
And the one thing I would caution or recommend to board members is don't try to be the expert on your condo docs. That's what you have an attorney for. Reach out to your attorney, let your attorney provide the interpretation of what that means. That was because it was written by an attorney, so let an attorney also be the one that decides what you should and shouldn't do. That's always good advice. One of the first poll question that I asked was, when do you have elections? And so this is a timely call because 83% of our respondents that have responded so far have elections January through March, so in that first quarter. And then another 10% have it in the fourth quarter. So that makes up 93% of all the elections for the people participating today are either first or fourth quarter. So and that's when most people are in Florida as well. So it's a good time to do it. It's also timely to have this conversation. So this is should be very useful to those that attend. And I do see your question, Charles, about the availability of this. You guys don't have to write any information down. This webinar is recorded. It'll be sent to you by tomorrow. So if you want to go back and listen, you might want to just mark what time it is so you don't have to listen to the entire conversation. If you see that, at 20 minutes in, we're talking about something very useful to you, you might want to mark that in so that you know where to go to when you get the recording, and you don't have to start from the beginning to figure out where we have this discussion. So that's a good question. Thank you for that, Charles. So Bruce, I want to come to you and ask you this question. There's a lot of work that goes in preparing for an election in advance. So, what kind of a timeline should board members work from a best practices as far as, considering what do you need to do leading up to the election? And then David, you can jump in and talk about, what are the critical timelines, the critical steps, the notices that need to go out and those things. But Bruce, just from a more of a planning standpoint, what do board members need to be thinking about leading up to an election?
Well, the first thing we want to do, Tim, is we want to count back 60 days because the process requires a 60-day notice through this process. David hasn't gone over that, but he can maybe go over that in a bit from a technicality standpoint. So the idea of management is to be talking to your board. Your declaration usually calls for when you're supposed to have election. Now, there are things that do come about. Those are the things that you consult with your attorney if you're going to extend those timelines. But from a management standpoint, once we have an idea of what day that election is, we count that back to 60 days because what we want to do is a few weeks prior to that, we want to get our attorney involved. Our attorney is going to prepare a package, and what we call that is an election package. that election package is going to go over the information sent to the residents, sent to the owners of the association, letting them know that we're going to have an election. And if they would like to put their names into the hat to run and so forth. I know that there are some associations, it's a bad practice to be using past documentation. You shouldn't be doing that. You should be getting up-to-date documentation from your attorney. Managers should not be changing anything around, because what's being sent out, at least I consider it's the legal document. We want to make sure that everything is up to date in regards to our declaration and up to date with the statute. Things do change. So we want to make sure that we're all compliant with that. So once all of that is there and together and we get that package back, the days of sending it out, of making copies in an office, I don't recommend. It's a waste of time. Make sure you have a printer on hand so that, you could get those printed and sent out so that, everybody receives it on time. Because we really want to make sure that everything is timed correctly, and so that we meet the statutory requirement of the 60-day notice. In a homeowners association, it's depending on your deck and what your deck is calling out specifically of when notice goes out and how notice needs to go out also. So it's a little tricky when you're dealing with 720, then 718, from then 719, which is a co-op. Some of them run very similar to condominiums in how they do their work, but it's going to be back to the declaration. Make sure, most importantly, you have someone like David on hand to give us some good guidance and so forth. And that's our responsibility for, getting out that first set of documents. Once we get that out, Tim, then it's the 30 days in a condominium. We want to make sure that we get bios. If a candidate would like to submit a bio, want to make sure that bio is within regulations of one page. Want to make sure the ballot is correct. Also make sure the attorney's preparing the second notice, and then so forth. So that's really the process for management, and that's how we kind of map it out so that we know that we're on time and everyone's receiving that. I highly encourage, which we haven't talked about, which may be down the road. That's the old way. There's still the new way, which is what's called electronic voting. That's out there too. We'll talk a little bit about that during our conversation, I'm sure, but there's also the electronic voting way too, but I don't want to, shoot the gun too quickly on that.
Okay, so thank you, Bruce. One of the points that you made though, Bruce, one of the poll questions is, do you have your attorney or a third-party company monitor your elections? And 2/3 of the people said yes, 1/3 say no. So David, can you talk about what are the benefits of having the attorney at the election to make sure that whether it's contested or not, what's the benefit of having an attorney there?
Right, great question. So, as an association lawyer, I do quite a bit of attendance at the annual meetings and helping clients with elections. Not for every client, of course, but for many of them, I do attend. We do try to talk ahead of time to flush out any issues that might come up so that we're not surprised. But as we know in this business, sometimes you do get surprises. So one of the main benefits of having a lawyer there present is to help with those questions that come up on the fly. As an example, with the condo election system, there's a 2-envelope system, which we can get into details what that's all about. What happens if it's, it's supposed to be secrecy, right? A secret ballot. And so what happens if the owner did properly sign the exterior of the outer envelope, but the inner envelope that's supposed to be secret, what happens if they also sign their name to the secret ballot, right? Do you count that or do you throw it out because it's now not secret? They revealed their name. The lawyer can help you with that fact pattern. There's a case on point that says owners have the right to waive their own secrecy. So if they sign that inner ballot, even though they're technically not supposed to because they lose the secrecy, they made a conscious decision to sign their name and waive the secrecy. So that's not one of the reasons you automatically throw a ballot out. That's an example of something that gets missed quite a bit. And in general, you really don't want to be throwing out ballots unless you are on very firm footing with a justification to throw it out. That is restating the obvious, of course, but if these elections come down to 1 or 2 votes, if it's not done properly, you may have to have a whole nother election.
So
Hey,
along
Tim,
the-
can I add something to that if you don't mind? And this is, there might be some managers and there are some boards that have done things, year after year. It's really important to have the professional there. I know that a lot of boards fall back on their manager. But one of the things that I can tell you in this business year after year, there is that one time where it is contentious. Having the attorney at the meeting is the optimal way of running an election. It is really important to understand either the attorney or the election monitor. If anything does happen, it's going to require legal advice, and it's going to require a response to the Department of Business and Professional Regulations. So having them run it is a much better way of making sure that everything is smooth. And I know it's good money. We don't want headaches. We just want everything to go smooth, whether it's going to be an easy election or a contentious election. Don't, this is not a place where you probably want to save dollars. This is a place where you want to spend dollars. And I just want to make mention, because a lot of associations kind of fall back and just saying, oh, the manager will run it, the manager will run it. So that's his best practice, that's out there and should be out there.
Okay, thank you for that. So David, Bruce started to allude to some critical timelines. So what are the critical timelines that boards need to be aware of that if you don't follow them could invalidate an election?
For sure. For condos and co-ops, as Bruce mentioned, there's the first notice that goes out, first notice of annual meeting has to go out 60 days before the annual meeting / election. That lets people know the date, and then it also lets folks know what they need to do to be considered a proper candidate. That then leads us to the next deadline, which is 40 days before the election. That's the cutoff time for condos and co-ops for a candidate to express their written notice of intent to run for board. Then the next deadline is 35 days. That's the deadline to get in your 1-page resume or bio that will go in the second notice. And then for most associations, condos and co-ops, it is a second notice that has to go out not less than 14 days before the annual meeting. And then of course the election takes place at the annual meeting. So that procedure, I call it a very beautiful thing. The reason I call it a beautiful thing is there's clarity and there's time. I get calls all the time from clients on day 39 or day 38 before the election. And they say, hey, Dave, 2 days ago was our cutoff. We have 3 open spots. 5 people are running. We're not so sure if 1 or 2 of these folks are actually a proper candidate. Help us figure that out. And then we have time to get, look into it and then make the decision before the deadline to send the second notice goes out. You usually have a couple of weeks there between those 2 things. In the HOA world, you oftentimes don't have that. Nominations must be allowed from the floor for a homeowners association unless the governing documents state otherwise. For many years, the HOA Act, Chapter 720, said you must allow nominations from the floor, period. That's what it used to say. And it was problematic because you never quite knew if you're going to have an election or not until you went into the meeting. And a lot of times on the fly, you were having to figure out whether someone was a proper candidate or not. Whereas condo and cooperative, your siblings, sibling associations, they have more time. So they changed the statute for homeowners associations a couple of years ago to say that if you have advanced nomination procedures that are condo, you can amend your bylaws to adopt those, and then you don't necessarily have to have nominations from the floor. So a homework assignment for any of the homeowners association folks out there, homework assignment is check your bylaws. If they're not following the condo co-op procedure, candidly, as you mentioned, that's really good use of your time and funds to get that amendment on the books. Community association law, in many respects, is like dental work. Okay, stay with me, everybody. What I mean by that is it's typically always better to spend your dollars on proactive dental work as opposed to reactive, meaning after the fact. So some money spent heading into this election to avoid the lawsuit. The lawsuit's like the root canal that comes later, right? Not pleasant and can be much more expensive than if you just went in for your yearly cleanings and checkups and everything. So that's my amazing analogy for this webinar. It's the only one I got, so I decided to use it early.
So one of the questions that was asked on our poll question was, for the listeners, do you typically get a quorum to have an election? And everybody that responded said yes. So actually 87% said yes. So most everybody does have a quorum. And so talk about that. Like what do you need in a condo versus an HOA? What do you need to actually have an election, and what's it mean to have a quorum?
Right. So for condos and co-ops, a quorum is whatever your documents say. For the majority view is a majority, majority of all the owners. That's the most typical quorum, but sometimes you see it deviate from that a little bit. But the Condo and Cooperative Act talk about, even if you don't get a quorum, if you have 20% vote, you still have the election, right? So you still have the ability to have the election even if you don't have a quorum. That same language is not contained in the homeowners association. So that can be one of, again, I mentioned HOAs as the Wild West. That's one of the things that's a bit of a challenge is, you don't have that same provision that you see in the Condo and Cooperative Acts.
And so another question was, do you have enough candidates running to actually have a contested election? So what if you have 5 board seats and only 5 people running? What happens with the election?
So in that fact pattern for condos and co-ops, you don't have an election. If they are proper candidates, they will automatically become board members at the annual meeting. At the conclusion of the annual meeting, they'll take their seat because there won't be a need. You only have to have an election, of course, if there are more candidates than there are open positions.
If you have 5 board seats and you have 4 people running, let's say, or 5 people running, no reason to count the votes. The people running automatically roll into those seats.
Sure. Yep. That's the way it goes. And now I will say this, a lot of condos and cooperatives in particular, some HOAs, but more common condos and cooperatives, there's 2-year staggered terms, and sometimes with resignations, there can be question marks about how many seats are actually open for election. If you're not sure, you want to have that dialogue with your management team and your counsel or your attorney. Candidly, you want to have that conversation well before the first notice even goes out. I mean, technically, you could wait until after the first notice, and you really would have to decide before the second notice. But it's a good idea to have all those questions outlined and answered well before the first notice goes out, so there's clarity. If there isn't clarity and you have to figure things out as you go, oftentimes that leads to allegations that favoritism or lack of transparency. And with elections, particularly this being Florida, we all know elections can be close in our states. You want to avoid all that. You don't want to give any type of perception that there's any favoritism or shenanigans going on.
And speaking of shenanigans, Bruce, where's a good place to store ballots when they come in, so there's no shenanigans with dealing with ballots up in advance of the count?
Tim, I've seen the gamut. I've seen cardboard boxes out of boxes that paper have come in. I've seen wood boxes. I've seen steel boxes. I've seen boxes mounted to the wall. Look, the bottom line to it should be in a safe place. Most of the time, where you keep it in the manager's office. It should be under lock and key. It should be. Some like to keep it in visual of the administrator that's there, or under a camera. We're trying to do the right thing there, and I know that there's a lot of stories that have gone on there, but proper place would probably be in the management office, in a sealed box. It should be in a sealed box, and somehow, or some put a lock on it, and that's probably the best way to accept the ballots as well.
Okay, good. Yeah, you don't want me to put it in the trunk of the car I don't drive, right?
No, and you don't want it to end up in the door. And what you like to do is you like to ask people to place their ballots in the box. Let's not, sometimes we have a few people in the office, oh, put my ballot in the box, and then all of a sudden my ballot's not there. We'd like you to put your ballot in the box. So it should be accessible to the owners as well.
All right, excellent. And David, I don't know if you have anything to add to that as far as receiving and securing the ballots.
Yeah, I echo all of that. It's you want to instill confidence in your owners that this is being done the right way, and you want to avoid any type of hint of shenanigans or variety.
What would cause an association to have to reissue the ballots? A lot of times we hear complaints that, well, my name was at the bottom of the list, so I didn't get any votes. It's like, well, do you list them alphabetically? Do you do it by beauty? Do you do it by age? Like, what's the best way to list, and what would cause association to have to reissue ballots?
Right, great question. So you do list the names via alphabetical order by last name, right? So that's, I believe that's also in the administrative code as well. So here's what's interesting about elections. You mentioned what is what they call a deadly sin, right? What is something that if you do, it automatically invalidates the election. I'll list those off for you here in a minute. Know this though, before I list off what we call the deadly sins, even if you haven't committed one of the deadly sins, if there are so many other challenges, there are cases where a judge or arbitrator has said, okay, even though a deadly sin wasn't committed, there was so much that was done incorrectly here that we're holding a new election. So before I list, just want to make that clear. Just because you didn't commit one of these four doesn't mean you're home clear. You still got to do everything correctly. But these are the deadly sins, meaning it's game over right from the beginning. Failure to send the first notice by the 60-day deadline. So if you blow that and you send it out 58 days in advance, that's a deadly sin. You've got to start over. Failure to timely deliver information sheets for each candidate in the second notice. That kind of restates the obvious. If there's 5 candidates running for 3 spots and you've got a resume from all 5 and you inadvertently only put in 4 resumes and somebody was missing, that's an automatic do-over. Failure to include the names of all the candidates on the ballot, again, that's an automatic do-over, no brainer. So those are the primary deadly sins. But again, you're still not home free even if you've adhered to all of those. Those 3 are pretty basic.
So we have a couple questions around that, some of those deadly sins. One of the questions that came in said, should somebody check candidate credentials when they come in? Like, do you believe what somebody claims their credentials are? Should somebody check that, report back to the association whether or not there's been some fabrication of qualifications?
What do we got, a Republican Santos situation here, huh? We want to check qualifications. Go ahead, David. So we would have a chuckle on that one.
No, just kidding. I've got a lot of family and friends in Long Island, so I kid. But no, it's in terms of the resume that people provide. Okay, there could be some embellishments there, and I know this may be hard to believe, but sometimes candidates seize the opportunity with their one-page resume to offer up their criticisms, or as my mother-in-law refers to them, improvement opportunities for the existing board, right? So sometimes those one-page questionnaires and resumes can contain all sorts of strong words about the current board or allegations or things like that. And it's a challenge. I've had clients call me and say, this person's resume has bold-faced lies about the current board. Obviously, we don't have to produce it. Well, there's cases that talk about it. You have to reproduce what they give you as long as it's within the dimensions of the one page, and that goes out, right? So we don't really have the ability to censor things now. If it's truly egregious and, borderline slander, libel, that's maybe something we can look at. But for the most part, the short answer to your question is what they provide. There's nobody fact checking the resume. We are relying on the candidate. And if they've embellished some things and said, for example, they graduated a college that they didn't go to, there's nothing we can do at that point in terms of correcting the information.
Well, just because they wrote it doesn't mean you have to believe it either as an owner. If you read something and you believe it to be false, you don't have to believe it. And that shouldn't sway who you're going to vote for unless you don't believe somebody.
Tim, I want to add that if you go over the bio and the bio is in question because it's inflammatory against somebody, or they're making, they're putting statements in there, let the attorney read through it. Let them, make the judge if this is a document that can be sent or can't be sent. It's better to have that legal to go out, because you surely want to make sure that you're being fair to all the candidates, and that, the information that's going out is legally accepted from that end. And we've had that in the past too, because some of these can be very egregious and very nasty and so forth. So it would be a good idea to have the attorney check it out.
Yeah. Okay. And when somebody identifies themselves as being a candidate, another really good question is it the responsibility of the property manager to check that the candidate is up to date on their maintenance fees? And what would preclude somebody, David, from running if they haven't kept up with their maintenance fees?
Yeah, that's a very important best practice. The statutes for condos and cooperatives say that your deadline to be eligible is the 40-day deadline to express your notice of intent to run. And one of the things that makes you ineligible is if you have delinquencies, right? So, we had that issue come up yesterday for a client. Somebody hadn't paid the January 1st assessment, and the 40-day deadline to express the notice of intent to run, I think, was like January 15th or something like that, and they were still delinquent. So they were no longer a proper candidate because they failed to be up to date.
So even if you get up to speed by the date that the votes counted, if you were delinquent at the time that you submitted to run, you would not be an eligible candidate. Is that what you're saying?
They clarified that in the statute a couple of years ago. It didn't used to say that, and then they clarified it to say that the marker is that the 40-day deadline for condos.
Hey, Tim, can I ask, I want David to make something clear. So if you have a candidate that is in that scenario, and they say, I'm going to make a payment, and they made a wire payment, but it didn't hit the ledger, but they do show there's a payment there. Can that be accepted? That it's not showing on the ledger, that it hasn't hit because it hasn't been received, but they do have confirmation that they did make a payment. So just, we've been in those situations. I just like you to clarify that for our guests online.
Yeah, so the specific facts can determine the outcome, right? So in that fact pattern you gave right there, one thing we always think about is if we end up in front of an arbitrator or down, a judge or something, what are their thoughts going to be on the situation? If we've got some evidence that they paid, even though they technically haven't paid by that deadline, if the facts are such that it's pretty apparent that it's there, it just hasn't hit your coffers yet, the answer there could be you go ahead and allow them. Now, I have not researched that particular issue, so there may be an arbitration case out there. But piggybacking on what I said earlier, the nice thing in the condo and the co-op world is if you have that fact pattern on day 39 and you're not sure what to do, you've got a buffer. We don't have to decide whether that person's a candidate or not until we lick the stamps on the second notice. So you've got a little bit of time. You can consult with your attorney. Your attorney can look to see if there's any cases that have addressed it. But typically that's not the fact pattern. Typically the fact pattern is someone is woefully delinquent or not. And if they're woefully delinquent, it's a no-brainer. If they're not.
So a couple of questions about candidates again is, and we've somewhat answered this question, but do you have to submit a fact sheet or bio? And the answer is no. You don't have to submit a fact sheet about yourself if you don't want. It typically helps get people to know you, especially in larger communities. If it's a contested or you've got 10 people running for 3 or 4 seats, it's a nice thing to do because people might make a decision based on the level of experience you have. Or they might see that you hail from Greenville, North Carolina, and they're like, hey, I used to live there. I'll vote for you because I see that. So not a bad idea to submit a fact sheet, but you don't have to. And then another question, David, is like, what constitutes a proper candidate? And so I guess, the point would be like, what do you have to do to qualify to be a candidate for your HOA or your condo to run for the board?
Right. So you've got to look in 2 places. You've got to look to not only the statutes. I know the statutes talk about certain types of felons who have not had their civil liberties restored, and that can disqualify you from the statute standpoint. But then your governing documents can further restrict who can run. For example, I probably once a year I get a panic phone call from a client that says so-and-so is a tenant and they submitted their notice of intent to run to the board. Surely we don't have to allow that, right? And I say, well, it doesn't say in the statutes that you have to be an owner to run for the board. Most governing documents say something like that, or they say a spouse of an owner or something, but there are occasions where a tenant can actually run for the board. So another homework assignment, check to see what the criteria is. Do you have to be an owner? Does your name have to be on the deed, or can you be the spouse? You know, for example, John Doe owns lot 101 or unit 101. Jane Doe, the spouse, is not listed on the deed, or vice versa. Unless the documents say owner or the spouse of an owner, then the spouse can't run, right? You know, unless they clarify. So you've got to pay attention to that criteria.
Okay, very good. Thank you. Let's see, the next question that we have is, it asks about, can you discuss responsibility of the nominating committee? So not every association has nominating committees, so distinguish why you would have one and what their role is.
So this is an area where many documents, if they haven't been rewritten in the modern era, you could have documents that say things like, to be a proper candidate, you shall be nominated by the nominating committee, right? And that type of language is outdated. Now, that does not mean that you can't have a committee that can recruit, right? You know, recruiting potential candidates. So this is an important job, and you want to make sure you've got folks that are qualified and are going to do a good job. So you can go out and encourage people to run. But as far as if there's a provision in the documents that says you can only become a proper candidate if the nominating committee blesses you and says that you're a good enough person to run, that's not a requirement. We look to the other criteria to see if you're suitable and meet the criteria to run. But being good friends with the folks on the nominating committee, that by itself isn't a requirement.
And so when you get I've got my my condo package right here on my desk. I've been on the board for a long time. There's things called term limits, David. So can you discuss what term limits are, and can you stay on the board if you exceed the term limits? What would qualify you to still stay on the board?
Right, good question. So term limits, there's the statutory term limits, and then there are also term limits that may be contained in your governing documents. There was a ton of controversy and indecision, candidly, from the Division of Condominiums a couple of years ago when they added in a provision that talked about term limits. And essentially, you, after 8 years of being on the board consecutively, the language of the statute said that you were not able to run again unless certain things happen. One of the exceptions, for example, is even if you've been on for 8 years, if nobody else was trying to run, there wasn't going to be an election because there weren't enough candidates, then you could still be on, right? There's a couple of exceptions to this, but they added that to the statute a couple of years ago, and nobody quite knew, well, was it retroactive, right? Was it just starting from that point in time? I think it was 2018 maybe when that first law hit. So the question was, do we have to worry about this now for somebody who may have been on the board beginning 2011? Or do we only have to worry about this going forward in 2026? They finally clarified that, and it's going forward in time. So that particular statutory provision is not retroactive. However, governing documents may also contain term limits. And I typically don't like to see that. When I do document re-art projects, I typically avoid putting in term limitations just because so many communities have a hard enough time getting volunteers to do this work that if you have somebody that's good, you don't want to necessarily take them away just because of the term limit. But some communities do want them. And my position is, term limits contained in your individualized governing documents are enforceable. But they're more rare. The term limits that most folks ask questions about are contained in the statutes.
And so that's a good point. And it's good that they clarified, because there were a lot of questions around term limits when it first came out and a lot of confusion around it. But once the legislature clarified that it was from 2018 moving forward, that it now becomes a 2026 issue, technically you could be on the board for 16 or consecutive years or longer than if you had been on for a long, long time. So it was good to get that clarification. Rick in Boynton Beach asks, once the election is held, can the actual number of votes for each candidate be revealed and posted?
It's a good question. So this is how I handle it. I just had this come up at an annual meeting I went to in December. And the way I handle it is I am handed typically as the lawyer, I'll be the one announcing the results. I get handed the tally, and then what I typically do is I reveal who won and don't automatically volunteer the tally. But I say to folks, if you want to see the tally, you can come up here, and of course you can set up an official records inspection to review each of the ballots, and we'll give you that data. But I typically don't automatically offer that up. And the main reason is I don't want to be in a situation. Sometimes the vote tallies can be, people might get embarrassed or something if they didn't get that many votes, and you don't want to hurt anybody's feelings. But don't misunderstand me. Everybody in the community has the right to know what the tally was, but there's no obligation for you to broadcast that immediately at the annual meeting. You can't just announce who the winners.
So you can make it available on demand then.
Yeah.
Okay, great. Bruce, you deal with a lot of elections and been to hundreds of these things. And one of the questions that we received, it's kind of an interesting question, is came in from Kathleen that says, why do you think elections have become so contentious? So what causes contentiousness inside these elections, Bruce? And what do you think? Do you think it's worse today than it was, 10 years ago?
I think the landscape has changed over the years, Tim. There are a lot of things that have happened in the last couple of years that have really made residents tight or concerned about things. Such things that we, people on this webinar, or if you've read in the paper and so forth, statutory requirements of reserving, the prices of insurance going up, just the way services are delivered to associations, and the ability to borrow money, the ability to invest reserve cash. There's a lot of things going on now in associations that have been very quiet over the years. I've never seen so much construction work since I've been in this business that's happening. So a lot of these decisions, and what owners have to realize, is it's the boards that are making these decisions. And what's happening, these hard decisions, remember, these board members are homeowners, they're residents of your community, they're paying the same exact fees that you're paying out there. And it seems that people are not happy with those decisions. So, this is just a very big climate for us, even in our country, of what's going on also, is that there are people that are standing up and saying, look, I want to change some things. Look, if you're not happy with something in your association, it's you that can make a change. I always say to someone, you could sit here and complain, but if you don't run and you don't take part, or you don't volunteer for a committee, you're never going to see change happen. And the change takes time, because it's not like you can snap your fingers and say, hey, let's make it happen. There's great thought. There is great time invested into boards. So if you're going to run for a board, understand it's a responsibility. Understand that it is, you are making decisions for, all the other people that you live with. And sometimes that is not always the most desirable or the most favorable decision. But hopefully you understand that you're trying to make the best decision for, the people that are in your community. So that's just some of the reasons that are out there of, what the marketplace, it's almost like taking a pulse on the marketplace right now, Tim, and what's going on out there. And that's what these boards have right now to deal with.
David, I'll ask you the same question, but I'm going to pick on one thing before I let you answer that. And I pick on social media, because, there are people out there that will create a Facebook page or whatever, platform they choose to use, and then they just fire off nasty grams all day long. And it gets associations riled up. People come to meetings and elections, and I think that creates a lot of contentiousness, just like our country. I think a lot of what goes on in our country is driven through social media. Anybody that wants to have an opinion can have it and share it with the world instantly, whether you know what you're talking about or not. And that happens inside associations on a smaller level. And I think that a lot of boards, like Facebook, is a dirty 4-letter word in a lot of associations, because that's a platform for people to just complain and gripe.
For sure. Having done this for a couple of decades now, I can definitely say that civility is in the decline here in the past, couple of years. And I think you've hit upon, probably the reasons for that. Also, while civility is on the decline, I'm kind of on the front lines. You gentlemen are on the front lines as well. It seems to me that the actual needing to have an election, the percentage of my clients that actually have an election where there are more candidates than open spots, I think that percentage is also dropping. It seems to be more common in 2022, 2023, where a client will just say to me, well, there's no election. We just didn't have enough candidates. It just feels like in 2013 or so, it was more common to have elections than you have now. And maybe the two are linked. Maybe the lack of civility means good people who want to run for these things are just like, I'd rather sit at home and watch reality TV than dip my toe into that nasty pond. That's what I think a lot of people think of.
That was a question we asked in our poll question, David, and 78% of the people responding said that they typically have enough candidates to have an election. So, but it's, it's a small population of the state, and we get people who typically join our webinar are engaged, knowledgeable boards, and those communities are more likely to have more people running and actually have elections. So I don't know if that's typical throughout the state, but that's what our poll question showed today. So let me take I'm going to ask one more question that came in before I go into the electronic voting side of things. Ed asked the question, if the property is titled in the name of a trust, who gets to vote?
Right, so there's a statute directly on point that talks about that covers, I believe offhand, it refers to beneficiaries are eligible to vote. And I think it does include a residency requirement there as well. Beneficiaries, and I believe it also addresses trustees, but there's a statute directly on point. So if you find yourself in that situation, definitely check in with your attorney so they can find that statute for you so you can make sure. And there have been times where a client has said to me, hey, Dave, we know what the statute says. We know when it's held in trust that who can be a proper candidate, but the person said there's no way they're going to show us the trust because there's sensitive information, as an example, or different iterations of that fact pattern. Sensitive information can be redacted, right? We don't need to know what an individual's net worth is, right? We just need to know, we need enough information so that we can say, yep, for sure you are a proper candidate or not. And in terms of pitfalls and common mistakes I see, just the simple thing of making sure your roster is updated. If it is owned by an LLC or a trust, have that dialogue. Make sure you know who's actually going to be voting on behalf of it. And if there's any questions, ask those questions leading into the annual meeting and election. The last thing you want to do is have an election come down to 1 or 2 votes, and you're staring at a unit or a lot owned by an LLC or a corporation or a trust, and you haven't done your homework to know whether or not this is actually coming from the proper person. That's not a good situation to be in. So do your homework ahead of time.
Okay, thank you. I'm going to hit a couple of questions and we're going to talk about electronic voting. Celeste in Palm Beach asked, can a current board member campaign for a new candidate running for the board?
Good question. So first things first, the resumes can say what they say, right? If somebody's been on the board for several years, they have the right to put that in their one-page resume. But in condos and co-ops, it specifically says you cannot identify who the incumbents are, right? Like on the ballot, you can't just put an asterisk next to who the incumbents are. That's a no-no. In terms of, board members are owners too, right? So just because you're on a board doesn't mean you lose the right to maybe campaign for one of your buddies that's going to run for a board spot. But you need to make it clear that when you campaign or you go door to door with your buddy who's running, you need to make it clear, even if you're on the board, you're not there in your capacity as a board member. You're then there as a capacity as an owner trying to talk up your good buddy who's here. That's a fine line. You don't want to say, I'm on the board and I know all, and give the impression that the board is somehow endorsing your buddy who's running. That's a no-no.
Okay, that's a good distinction. That's a very, I haven't heard that clarification before, so that's really good. Is if you're going to campaign as an owner, not as a board member. And there are, I mean, look, there are a lot of people that run on a ticket. It's like, hey, vote for the four of us because we all, they may actually campaign in the neighborhood and put flyers out or whatever and say, here's the four people you should vote for. Like they can campaign, but they're campaigning as owners. Celeste also asked, during the organization meeting after the election, what happens if there's a tie for when they vote for who the president's going to be? How do you break that tie?
Right, so that is a good question. You know, first things first, you look to your bylaws to see what it says. Most bylaws say that, you know, the directors vote for the officers, and you have the ability to do a secret ballot. Excuse me, that's one of the few situations where boards can actually vote via a secret ballot. If you can't get any clarity on that, again, you look to see what the bylaws say. If they're silent, you know, oftentimes you just go without a president until you can figure it out, right? And then there is the ability, you could voluntarily, if there really is not a way to get to the bottom of it, right? One potential option, this is very rarely used, but you could have an actual, I have seen boards say, we're at a stalemate. We know we don't have to do the following, but the board collectively has decided we are going to do the following. And the following is we're going to actually have a kind of a second election for the presidency voluntarily where the owners get to decide. That is very rarely utilized. I've only seen it once or twice. To clarify, that's only in a stalemate when there's nothing else clarifying things in the bylaws. Most of the time, you get somebody finally says, all right, I'll go ahead and I'll vote for this president. And sometimes they say, if you vote for me for VP and I vote for you for president, we've got a deal as long as you promise to work with me real closely. And typically you can work with me.
But I'll be clear on this. The tiebreaker is not who got the most votes. So a lot of times people say, I got the most votes, I should be president. It's like, it doesn't work that way. You still have to have the organizational meeting and you decide what role each person plays in the organizational meeting.
For sure, great point.
Charles and Key Biscayne had a couple of questions. Bruce, I'll ask this one to you. Can a property manager and a unit owner sit alone validating sealed ballots?
Well, usually what the attorney will tell you is that you want independent parties. Management is considered an independent party. It's not the most optimal scenario here. You really want the counters, in my opinion, and the way that I've done them, to come from the residents, from the peers of the community and so forth. But if it came down to it that there wasn't enough representatives, I would say it would be okay to do that. Considering that management's considered impartial or should be impartial. And then the other hand is the other counter, of course, should not be related to any of the candidates that are running. That should mean immediate family, partner, or anything of that nature. And usually the attorney will go over that prior to meeting of selecting what we call election monitors or counters or whatever you want to, classify them as.
And so, Bruce, there were a lot of questions around Zoom a couple of years ago, especially as Zoom became this popular way of holding elections and still holding board meetings. Just from a practical standpoint, do you find that most elections and counting of votes are being done under a camera now so that people can see that it's all legit?
I think a lot of associations like this hybrid thing, and they prefer to do it that way because they want people involvement. In contentious elections, I remember, we used to film them. And, before the Zoom days, before you had that, where, they wanted to see every step of the way so that if there was something that went wrong, they would be able to go back to, I feel like, Warner Wolf back in the New York days, let's go to the videotape, and everybody wanted to go to the videotape. But, from that end, I still see that happening. I still think it's more of a convenience of a type of thing so that everyone can partake in the election and see what's going on.
And David, what's your guidance around Zoom board meetings and the viability of that?
Right, so it's an important topic. It's evolved a bit over the years. Obviously, at the height of the pandemic in 2020, when people weren't even leaving their homes for the most part, you could be a little bit more aggressive on this issue. But here's the reality. The reality is we still don't have clear-cut authority as to whether a Zoom only membership meeting is legit or not. Okay, we still don't have clear-cut authority. And so, back in the height of the pandemic, state of emergency and CDC recommendations and all that, I had a couple of clients that had to do Zoom only, and we worked it out, and nobody really challenged it. In those situations, we, as Bruce was mentioning, we positioned the camera so that people could see it. But now it's 2023, COVID's still with us, but it's certainly not what it was in 2020 and 2021. So the bottom line is the hybrid approach that Bruce mentioned. I still am recommending to my clients, you want to have an in-person element so that if somebody wants to show up and observe all of this, they can. Zoom only opens up Pandora's box in terms of legal challenges. So hybrid's the way to go, or old school where you don't even offer Zoom. But as Bruce said, we have all become accustomed to Zoom, and it's a great way to build people's buy-in with the community and foster transparency, but still have the hybrid, still have the old school, in person. So if somebody wants to be there and see what's going on, they can. And a couple other best practices. One thing too that I see this is a common mistake, and you kind of hinted upon it in your earlier question. You can't go behind closed doors and open up the envelopes and count. That has to be out in the open. And folks, the arbitration cases say owners have a right to see what's going on with the rest of the annual meeting, while at the same time observing what's going on with the council. And if you do it in some closed room someplace, the owner has to pick and choose whether to participate in the annual meeting or observe what's going on with the election. That's why it all needs to be done out in the open. And typically it's done in the back corner somewhere, but still close enough so that if an owner wants to watch both things going on at the same time, they can.
So a cleaner way to count votes is electronic voting. So we have a few minutes left. Let's spend a few minutes talking about electronic voting. One of our poll questions was, have you moved to electronic voting? And of the answers we've gotten, 80% are saying no, 20% have said yes. That's probably about what you're seeing out there, isn't it, David? Maybe 80-20 rule on people that have adopted electronic voting. And what do you have to do to adopt electronic voting?
Right. So first things first, when it first came about, electronic voting, I think it was circa 2017 or 18, something like that. The first group of clients I had that were very excited about it were primarily the large condo associations with hundreds of units. They were excited about it because they oftentimes struggled to get the 20% for the election or struggled to get the quorum. So they were fine with dipping their toe into the electronic voting pond because they figured they had nothing else to lose, right? Because they a lot of times weren't getting these numbers to begin with. And then over time, more and more communities have done it. So let's briefly go over the steps that are required. First things first, the board cannot force an owner to vote electronically. An owner can only, there's a process where the board can give the owners the option to vote electronically, but at the end of the day, it's the decision of the owner. If the owner wants to vote the old school way and use the paper and lick stamps, that's up to them. So if your community wants to offer electronic voting, the first thing you have to do, there's certain steps that have to be followed. The board has to hold a board meeting. You have to notice that board meeting 14 days in advance, letting the membership know that you're considering offering. Then at that properly noticed board meeting, the board approves it, and it's a best practice to set into motion approval of the electronic voting consent form and all that good stuff. You also have to select a provider, the online provider that's going to facilitate the voting. And there's several different companies out there that offer electronic voting. Becker and Polycop, where I work, we have an outfit called beckerballot.com that does electronic voting, but there's certainly several other very good online voting platforms out there. So you have to select the platform, and then you have to notify the owners that they have that option. The nice thing about it is, if you've got an owner in Sri Lanka, they don't have to wait on the mail or send it back. It's as instantaneous as coming to their email inbox. Now, there's another username and password. It's the modern world. We can't get away from that, but you've got a username, a password. You receive the notices from the association. You click, you vote in the election of directors. You vote on the proposed amendments. You hit submit, and you're good to go. And then you don't have to worry about the mail personnel.
So one thing that's important is just because you have electronic voting doesn't mean everybody has to vote electronically. You have to opt in. If you choose, you can still vote by ballot and by mail-in ballot. So that's a personal choice for each owner in the community.
For sure. And as more and more, what I'll call the younger generation, the millennials and whatnot, come into these communities, electronic voting and electronic notification, it's secondhand. They're very accustomed to everything being electronic. It's the Gen Xers and the baby boomers a lot of times that aren't quite as familiar with it. But as communities evolve and folks continue to move in, there's more and more electronic voting that goes on. And for folks that have not experienced electronic voting, you may be thinking, well, how does it actually work? And the way it works is the manager, oftentimes it's the manager, will come with the laptop, log in to the online voting platform. The electronic voting tally will be shown, and then you count up the paper ballots and proxies the old school way, and then you combine the two numbers and you have your results.
Very good. So we're at the top of the hour, so I want to be respectful of our time. So if I can get one final comment, Bruce, I'll start with you. If you could if there's one piece of advice you would give to a board in preparing for and running a fair and unchallenged election, what would that be?
I think about being respectful to everyone. Everyone doesn't agree on everything, but we all live in the same community. And at the end, someone's going to win, or there's going to be a group of candidates that are going to win. Let's try to give them the opportunity to run the community. Let's be respectful of each other, because at the end of the day, I believe that everybody wants the best for the community, and their actions hopefully will show that as board members, because by taking a board seat, you're taking almost like an oath to really make sure that the business, the corporation, which an association is taken care of, and so forth. So let's be respectful of each other. Let's make sure that everything is done correctly. And at the end of the day, if you don't win, there's always another opportunity to run again if you'd like. So those, that would be my one piece of advice, of being kind and friendly, during an election.
So you're saying be a good loser.
Maybe, and be a great winner, because you got that opportunity to make change or continue the course.
David, what would be the single best advice you would give board members to have a fair and unchallenged election?
Plan ahead and be proactive. And what I mean by that is any potential issues that may be on the horizon, let's address those before the manager is in the parking lot of the post office, wanting to know if they can go ahead and put the notices, the second notice in or not. And pay attention. I mean, for example, I went to an annual meeting recently, and one of the issues was there was a married couple, but only the husband was on the deed, and he passed away, unfortunately, about a few weeks before the election. And so the issue came up, well, wait a minute, who's actually going to be able to vote for that particular unit? What are we going to do in that situation? And because the board had the foresight to anticipate that hiccup or potential issue, we were able to talk it through and get some clarity before the annual meeting and didn't have to disenfranchise anybody. So if you're hearing things, don't just dip your head in the sand. Try to find out as much information as you can, and let's be proactive to solve these problems well before the actual annual meeting.
Great, thank you. Great advice. So again, 84% of the people that responded today are having elections in the first quarter of the year. So this is a timely conversation. Hopefully it was very helpful. I thought we had a great conversation. I don't know where the hour went. It disappeared on us very quickly from this discussion. I'd like to really thank David Muller, managing shareholder with Becker, and Bruce Masia, vice president with KW Property Management. Gentlemen, you were fantastic. Thank you. For those of you listening, today's session is recorded. For those of you that aren't listening, you will get this recorded session tomorrow. So even if you signed up and you couldn't listen, you will get it sent to you. Don't forget, if you want to get a free COVID test, you can sign up for your COVID kits at covidtest.gov. And we look forward to having you join us again next month on February 15th as we continue to talk best practices for community associations, the third Wednesday of every month from 3 to 4 o'clock. From all of us at KW Property Management and Consulting, please be respectful to your neighbors and stay healthy. Thank you very much, gentlemen. Thanks for all you did today.
Thanks, Tim.
Bye now.
Thanks, Bruce.